Hi, my name is Natalia Willett and I'm a real estate attorney here in the state of Florida, and today I want to talk to you about permits. So one of the big things that takes place when investors acquire real estate is, of course, that they acquire them at a discount and in a situation where the property is physically under conditions that are less than ideal. Very rarely does an investor acquire a property that is turnkey. So what happens with properties that you have flipped and in which you have hopefully pulled permits, right? So I'm going to discuss a little bit about permits today and things you need to know. Number one, you need to be pulling permits for work that you are doing that requires permits. So you need to be aware of what the county or city that operates under, wherever you buy your property, what they require in terms of permits. What kind of improvements need permits? Big things like garages, installing AC units, installing windows require permits. Other things might be changing the garage door. You might need a permit for that. So you need to become aware of the types of permits that you need to be pulling. Even if you are doing the work yourself, permits are not something that just general contractors are obligated to pull. You as the owner need to do so if you are doing the improvements. Number two, so when it comes down to when you list the property for sale and you are advertising all these amazing improvements, new things that you've put in, you need to make sure that what you are advertising has been properly permitted. So if you did not do the work that put in that particular improvement, let's say you acquired something from a flipper who just didn't want to finish, didn't have the money to finish whatever he was doing, you need to make sure that you're not advertising things that they did that end up being not properly permitted, because you could get in trouble for misrepresenting under a contract. And then three, I wanted to discuss with you some of the consequences that can come up if you have done work on the property as a flipper, even under an as-is contract. So as-is contracts, of course, have under paragraph 10, and this is contracts in the state of Florida. So under paragraph 10, they have certain seller disclosures in which a seller has to say, what are the material things that are impacting this property? Improvements, of course, are material things impacting the property. So if you have failed to disclose that you did not do work, specific work on the house, permitted, you can be sued for breach of contract, and there is a cause of action for right there for misrepresentation, failure to disclose, all sorts of things. So be aware of this. Permits are important. And then under paragraph E, which is a standard section under the Florida Association of Realtors, Florida Bar, standard as-is contract, paragraph E very clearly states that if you have made any improvements to the property within the last 90 days, you must disclose not only that the improvements were made, but you also must provide proof to your buyer that you have made payment to any contractors, subcontractors, laborers, etc. that performed the work on that property, that performed that improvement. Because the risk there is, of course, if a material man or subcontractor performed some labor and you didn't pay them, well, guess who they're going to pursue next, right? So these are some very important things that you need to keep in mind when it comes to permits and improvements on property if you are a flipper. That's it for today, investors. Good luck out there.